and the one for Gladys Wambui. I have read all of them and taken them into consideration here. The issue now for determination is whether the investigators here should be granted leave to continue detaining the respondent for a further 15 days to enable them finalize their investigations. From the above statutory and constitutional provisions, it is clear that any arrested person is entitled to bail or bond before or after being charged in court, unless there are compelling reasons not to grant bond. There are many authorities that support this stand in Kenya, and I will only mention one due to time limitations. That is the one of Republic versus Danson Ngunya, and another which is 2010 Kenya Law Reports. From other jurisdictions, I'll quote one case. From Uganda, in High Court Criminal Application number 23 of 03, Tigawalana Bakali versus Uganda, the court stated, and I quote, bail is granted to an accused person to ensure that he appears to stand trial without the necessity of his being detained in custody in the meantime. The effect of bail is merely to release the accused person from physical custody, but he is still under the jurisdiction of the law and is bound to appear at the appointed time and place, end of court. The respondent here is the governor of Migori, hence a prominent person, as already stated before. The state is of the opinion that he will be able to interfere with the witnesses and the entire investigations if released on bond. That this matter being a public interest matter, the investigators have to thoroughly investigate whether the weapons found might have been involved in other crimes. The court therefore has to ask whether these are reasonable or compelling reasons to deny, whether these are reasonable or in fact compelling reasons to deny bond. It was stated by the respondent that the said Rapogi home is one of the places he was barred from through bond terms issued by another court, and he has no intention of going there. That he and his bodyguards have already recorded statements, and I also note that the officers who are said to have recovered the weapons are from the ENCC. There is a very remote possibility that the respondent will be able to influence these officers. As for the other witnesses who could have been at the Rapogi home during the recovery, the state has, as of today, had at least 3 days from the date of recovery to record their statements, visit the scene, take photos, and continue whichever investigations needed whatever investigations needed at the home. Any further investigations, like a confirmation of firearm data, mobile phone data, and others, do not require the respondent's incarceration to be undertaken, as he has no control whatsoever over them. And still on the said witnesses, on the issue of witnesses, so far none has been identified. So in my opinion, it will be hard for the respondent to interfere with these unknown witnesses. So far, the most probable charges the respondent is likely to face are those under the Firearms Act, which are all bailable. And from the judiciary's bail bond policy guidelines, I find that the most important one and relevant one in our case appears to be that of the presumption of innocence. And I'll quote a case here, R versus Danford Kabage Mwangi, 2016 KLR, and it was held, like what, granting bail entails the striking of a balance of proportionality in considering the rights of the applicant, who is presumed innocent at this point on the one hand, and the public interest on the other. The cornerstone of the justice system is that no one will be punished without the benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to assure that the accused person will appear for trial and not to corrupt the legal process by absconding. Anything more is excessive and punitive. End of quote. Way back in 1951, the Supreme Court of the United States observed in the case of Stark versus Boyle, 342 U.S. 1-4 of 1951, and I quote, unless the right to bail before trial is preserved, the presumption of innocence secured only after centuries of struggle would lose its meaning. End of quote. It is now my conclusion that the prosecution has failed to establish that the investigators should continue holding the respondent in custody. There are no compelling reasons shown to justify the denial of bond here. And after considering all the factors here, I am satisfied that the respondent is not a flight risk and will appear for trial if need be, and is not likely to tamper with the evidence or witnesses. I now therefore make the following orders. Number 1, the application here is dismissed. Number 2, the respondent is granted bond of Kenya shilling 500,000 with a surety of a similar amount or a cash bail of 200,000. 3, the respondent is ordered not to interfere by himself or his agents with the ongoing investigations, failure of which the bond here will be cancelled.